Peter. Hi, this is Josh Blackman, and I'm the president of the Harlan Institute. It's my honor to welcome you to the 2021 Harlan Institute Virtual Supreme Court competition. We are in the semifinal round, match number 9. Today, we're arguing the case of New York State Rifle and Pistol Club versus Bruin. Representing petitioners from the Joel Barlow High School is Emma Downey and Peter Martinich, and representing the respondents from the Baldwin School in Pennsylvania, Nina Akachukwu and Amelia Skowinski. Petitioners, are you ready?
Yes.
You may proceed.
Thank you, Your Honor. May it please the court. I'm Emma Downey.
And I am Peter Martinich. Together, we represent the petitioners for the case of New York State Pistol and Rifle Association versus Bruin.
In September of 2014, petitioner Robert Nash applied for a concealed carry license in the state of New York. Nash's license was denied on the basis that he could not demonstrate a special need for a gun permit and therefore lacked the proper cause to be issued one, despite the rapid rise of violent crime in the area. Also in September of 2014, petitioner Brandon Coach of New York applied for a concealed carry license. Coach, who pursued a concealed carry license for purposes of self-defense and who had an extensive background in the use of firearms, was also denied under the same New York law, New York laws, NY Penal Law 265.01 through 04 and New York Penal Law 400.00. Neither man had a history of mental health issues nor a criminal record. The denial of these permits raises the question of whether or not the Second Amendment allows the government to prohibit a law-abiding person from carrying handguns outside the home for self-defense.
So for a brief summary of our arguments, we look to use history and tradition tests to look at the regulation of firearms in the United States, as the court has recognized in the past that qualified individuals possess the right to keep and bear arms. And furthermore, the questions fail to pass when looking at them using the modern tests of intermediate and strict scrutiny.
Okay, let me stop you right there. What level of scrutiny did Heller establish?
We said that Heller had established intermediate scrutiny.
Did Heller use the word intermediate?
Sorry, what was the question, Your Honor?
What level of scrutiny did Heller establish?
Intermediate scrutiny, Your Honor.
Didn't Heller say heightened scrutiny?
Well, when looking at the case, we interpret it as intermediate scrutiny based on the prongs and how they related, and it's based on the
explain to me why you prevail under intermediate scrutiny.
Well, Your Honor, when looking at intermediate scrutiny, we think it's important to consider the fact that that first prong, that it must further the government's interest, is very vital for this case, because we believe that New York's law is in complete opposition of this. This, as found in the Second Amendment, it's the state's interest for the security of a free state, which is then taken away when the right to personal defense with a firearm only exists inside the home, and the right to security is lost outside the home. So, we believe that there is no social science research that proves the direct causal relationship between New York's pistol permitting regimen and public safety. Therefore, we think it'd be nearly impossible to prove a substantial relationship exists between New York's policy.
Right, but if we have, substantial evidence showing that guns are bad and guns lead to death, isn't the answer then to simply defer to the elected branch, let the state decide? Why are we in the business of making these decisions if the evidence goes, either way? And this is a question for Emma.
Well, I think that we as the petitioners don't believe that there's any social science to support that. But even if there was, hypothetically, we also can take into consideration that guns have the ability to make us safer too. There's a lot of instances in where people people enter into scenarios where they're not able to prepare themselves or defend themselves ahead of time. Like, for example, if you were walking along a subway in New York City, and in a scenario like that, a lot of times people you wouldn't have the ability to prepare ahead of time, or to do something like in the instance of Coach and Nash's case, you wouldn't have the ability to apply ahead of time to get a concealed carry permit, and you wouldn't have the.
Let me stop you for Peter. The subway, is the subway a sensitive place?
No, Your Honor.
So you think that carriage should be allowed in the subway?
Sorry?
You think carriage should be allowed on the subway?
Yes, I think that, yes, Your Honor, I think the Second Amendment
What about
specifically delegates. the right-
what about on college campus?
Well, Your Honor, I believe that it was distinguished in Heller that that part of this list was places of a on government grounds as well as on such as universities as well. And
So you
as
can't
those are
carry, you can't carry on a
places.
college campus.
Well, no, sir, because as we like to make clear, we recognize the fact that the right is not unlimited, but at the same time, we also so we recognize that carrying it at a school is, whether no matter the level is a danger. So we believe that could pose a threat, but at the same time, what about the areas around it? What about just general downtown and in a city or in a and even like a small rural community?
What about the entire island of Manhattan? Could the entire island of Manhattan be a sensitive place?
No, we do not believe so, Your Honor.
Why not? There's kids everywhere, there's schools everywhere. Why couldn't the island of Manhattan be a sensitive place?
Your
Well,
Honor,
if-
because,
But
sorry, Peter.
Ms. Downey,
Your Honor.
yeah.
Sorry?
Go ahead, Ms. Downey.
Thank you, Your Honor. And something like a vast area like the entirety of Manhattan would not be considered a sensitive place because it's not the reason that Heller specifically enumerated these specific carve-outs about government building and schools is because there are areas where they're particularly known that the presence of firearms and especially things like open carry where people can visually see them would cause some sort of substantial heightened panic or nervousness amongst the people inside. The entirety of Manhattan is not one of the carve-outs listed in Heller because it encompasses a very wide range of areas, including people's homes and things like that.
Counsel, I'm going to interrupt you there, and I apologize, but I kind of want to switch gears. I seem to remember your co-counsel somewhat providing an outline where he stated that history and tradition supported your position here. What is your best piece of historical evidence that supports your position?
Well, Your Honor, besides the cases of Heller and McDonald supporting our case, there's also a lot of historical precedent we can look to, not only in the case of United States versus Hayes in 2009, which
What did that hold?
It reinforced the precedent that individuals with domestic violent convictions could not legally own guns, and it strengthened existing protections for people who had been abused in domestic violence situations by prohibiting the people that attacked them from being able to legally.
Sure. And that was a Supreme Court case?
I believe so.
Okay, well, let me ask you this. What do you do about the Statute of Northampton, which predates the Constitution? It was an English statute that prohibited the carrying of firearms in public. Furthermore, this is for Peter, let me specify. What do you do about the numerous so-called good cause laws of the 1800s?
Well, I think I would like to, acknowledge the history in that case from long ago, but at the same time, it's important to look at it from a modern standpoint as well. I believe that, we have to draw the line somewhere to recognize that, history can go as far back as it can, but at the same time, we are trying to consider this from a standpoint in the 21st century.
Counselor, so history doesn't support your position, or it does?
No, history does support our position.
What history?
The president from past course cases.
So just case law?
We believe so.
Okay, proceed with your argument.
Counselor, first, I just want to clarify back on Justice Blackman's question from earlier. So I see in your brief that you actually do make an argument for strict and intermediate scrutiny. Just so I understand your stance, what do you believe is applicable here?
I believe both are applicable to prove that why this piece of legislation fails. Both test because, like I said previously, with intermediate scrutiny.
Which do you think is the best for the court to adopt here today?
I would say the best would most likely be intermediate because I think when looking at the state's interests, which we determined as the security of the free state, the New York's law just is in opposition of that. And we believe that yeah, when it's taken away, then that government interest falls through and therefore it fails the test.
Thank you.
Hey, about 30 seconds left. You want to wrap up?
Thank you, Your Honor. In general, we believe that the court's past precedents, specifically with intermediate scrutiny, lead us to the determination that the may issue clauses that are found within these laws are a violation of the Second Amendment. For just to do a general overview of our argument, firstly, that they violate the operative and prefatory clauses of the amendment, that they invalidate the centuries of historical precedent that back the rights enshrined in the Second Amendment, that they fail to prove scientifically or otherwise any form of government interest in which these laws could be justified, that they prove that the law is narrowly tailored, not narrowly tailored, excuse me, to achieve the best interest at hand, and also that they prove.
Thank you, Counsel. We're over time. Okay, thank you so much. All right, respondents, you have 15 minutes. Begin whenever you're ready. And yeah, let me. You there, Nina?
Yeah, I'm just unable to start my video.
Oh, I'm sorry. 1 second. How about now?
Yes, okay.
Thank you so much. All right, 15 minutes. Begin whenever you're ready.
Mr. Chief Justice, and may it please the court. My name is Nina Okachukwu, and this is my partner, Amelia Skavinsky. Today, we will be representing the respondent in regards to this case. We argue that the Second Amendment is not an unlimited right and that the limits of the Second Amendment allow for restrictions to be made in order to protect the lives of others. When petitioners applied for concealed carry license and were denied, it essentially revealed the Second Amendment's protections allow for restrictions to be made so that even a law-abiding citizen may be prohibited from carrying guns outside the home for self-defense. With all things considered, it is abundantly clear that not only is the New York law constitutional, but it is vital in order to protect ensure the public safety and lives of others, and should therefore be upheld. With the District of Columbia versus Heller, it was established that the New York law exceeds a person's desire to simply want to carry a gun for their own protection and requires the person to reveal a special need or a proper cause in order to defend themselves outside the home.
Heller said that?
No, it was established. It was essentially established this.
I mean, that's your interpretation of Heller, is it
yes,
not?
that's my interpretation.
Okay.
The petitioners, Robert and Brandon, their desire to conceal carry was precisely what the proper cause law is against. It is not just someone desiring to carry a gun outside their home. It goes much past this. It requires you to present a
Counselor, I'm going to interrupt you again. And this is for your co-counsel, Ms. Sawinski. Am I saying that right?
Skavinsky.
How are you getting that from Heller that the right to bear arms doesn't apply outside the home? Is it your contention? Let me be more targeted. Is it your contention that there is no right to carry outside of the home?
Could you please repeat the question?
Yeah. Is it your contention that Heller established that there is no right to carry a firearm outside the home?
So within our interpretation, we believe that Heller, if there's no special need, then no special need for
Counsel, it's a yes or no. Is there a right to carry out? No.
Sorry, I'm sorry. Could you continue?
Yeah. Is there a right to carry outside of the home per Heller?
No.
Okay. You can proceed with your argument.
Concealed carry has a long-standing history. As explicitly stated within the Heller case, the need for self-defense and the right to carry firearms is a right that lies within a person's home. This is supported by the Second Amendment, which further proves that the law does not burden the petitioner's right to self-defense in the home.
If I can ask you a question, Ms. Sawinski, could New York ban carry altogether outside the home? Just a complete ban, good cause or not, you can't carry a firearm outside the home. Could they do that?
I believe that if they think that there's a cause to completely ban firearms and there was a safety issue outside of one's person home, then I think it would, yes.
So, I mean, the Second Amendment has two verbs, right? To keep arms and to bear arms. This is a question from Ms. Sakachuku. What does the word bear mean? What does that add to the case then if you can absolutely ban guns everywhere?
I think if you're asking what is my interpretation of the word bear, then I think, is that what you're asking?
Sure. Yeah.
Then I think the term bear refers to someone's individual right to carry guns. I don't think
Where? Carry guns where?
inside their home.
So
I think
bearing
that
arms is only carrying a gun inside your home.
Yes, I think that there are limitations. I don't think it's explicit that it should, I think that it's not, when the word bear refers to someone's individual right within inside the home, yes.
Okay, you can proceed, counsel. Thank you.
I think you're muted.
Me?
I think it's your turn.
I'm sorry, Amelia. I don't hear you.
Can you hear me now?
Yes. Okay, go ahead. Proceed. You may proceed, counselor.
Thank you. In this case, and with the New York law, intermediate scrutiny can be applied as the level of judicial review, as this law looks to protect the interests and lives of the people. With that being said, the New York law should be upheld.
Well, let
So
me ask you. Oh, just Walson, go ahead, please.
So if it's your position that intermediate scrutiny should be applied, why not strict?
We believe that intermediate scrutiny should be applied and not strict. Intermediate scrutiny should be applied and not strict scrutiny because of the what the Second Amendment applies and how this applies to the case.
And if we were to decide that strict did apply, would you lose under strict?
I'm sorry, could you repeat the question?
If the court found that strict scrutiny was the right level of review, would you fail?
No, I don't believe so.
So you're saying that the New York statute is the least burdensome alternative?
I'm sorry, my speaker is not working very well. Could you please repeat the question?
So in order to survive strict scrutiny, the third prong, the New York statute would have to be the least burdensome effective alternative. Do you think that the New York statute is that?
Yes.
And my last question for you is, in terms of your saying it's the least burdensome effective alternative, how do you rectify that with the modern trend of most of the majority of states today allow their citizens to open carry firearms outside their home? Why do you think that New York should not join the majority of other states?
Well, I think it depends on not only populations, but the states and the history with allowing permits and their regulations within that.
Okay. I'd like to ask a question to your co-counsel, Ms. Akachukwu. What's your best piece of historical evidence here? Your co-counsel just mentioned history. What history and tradition support your position in this case?
I think there are quite a few cases. I think Hightower versus the city of Boston, and I think.
And where is that case from, and what did it hold?
I think that those cases, or the case that I just mentioned, essentially, I think it affirms that the core of the Second Amendment and self-defense lies within the home. I think that's essentially what I was trying to convey.
The home and the home exclusively is what you're saying.
Yes.
Only in the home. Now, and what do you do with the Heller, which stated that the word bear meant to carry, and the purpose of the whole carrying the arm was for confrontation purposes? I mean, confrontations don't just happen in the home, do they? I mean, one can conceivably get mugged on the street, on the way to work, on their way to the store. So, I mean, when we see that the purpose of it is to prevent confrontation for self-defense, to me, it just doesn't make sense why it's limited to the home. Can you please convince me as to why we should only limit it to the home?
Well, I don't know if I stated explicitly that it should. I think that if you're talking about the word bear, then it does apply to the home. But keep is a different term. I think keep. I think that I might have maybe misinterpreted, because I don't think that it is explicitly inside the home. I think that there have to be extreme limitations on carrying outside of the home. It shouldn't just be anyone being able, if you're just a law-abiding citizen, being able to carry inside the home. I think that there have to be extreme regulations.
And why did there have to be extreme regulations?
Because this is a case with protecting the lives and liberties of citizens, of people. And so if people are just carrying guns, for lack of a better term, willy-nilly, then people are going to get hurt, people are going to die, and it's not something that should be taken lightly.
Sure, but couldn't a background check prevent the willy-nilliness of firearms carry in New York just as well, if not better?
I think, well, yes, but I think that not just a background check, because you can be a person who has never had any past experiences with guns before, and you can still, decide one day that, you might want to do something to hurt people. A background check is vital, but it's not something that should only be considered. I think that some people might have not had any past criminal experiences before, and they still carrying a gun is something that is not something that should be taken lightly, and that's not something that should only be done in regards to background checks.
You can proceed with your argument, counsel.
Okay. So, contrary to what petitioners argue, rights in this case are not being violated. It's well within the rights of the government to restrict certain actions, especially regarding Heller and relating to the serious issue of gun violence. Along with this, concealed carry is not completely excluded. Like I said before, as the Second Amendment does protect the right to keep and carry guns and firearms inside the home, and for business owners within their place of business, because that is their right. The limitation is put in place for people in regards to sensitive spaces and public spaces. So it's like I said before, I don't think that concealed carry is completely out of the question.
And like my co-counselor has stated, the New York law is put in place in order to protect the lives of people where they may reside or spend time. These places may include malls, schools, subways, parks, and other spaces. This is well within reason and is sorely needed for people to have their own sense of safety. Continuing, additionally, the New York law does not even substantially burden the core of the Second Amendment right. Heller established the core of the Second Amendment as the right of law-abiding, responsible citizens to use arms in defense of heart and home. This interpretation has been upheld by numerous lower court decisions, most prominently in Hightower versus City of Boston, which cites New York State versus Greeno, Georgia Carry, .org Inc. versus Georgia, and the United States versus Barton, as long with United States versus Staten and United States versus Reese, as well as other cases which affirm that the core of the Second Amendment is defense of the home.
Councilor, if I could jump in, I'm gonna ask a question. How do you define sensitive places?
Is that a question for me?
Yeah, sure. Go ahead.
I define sensitive spaces as any government area or any place, any space that people may reside in or spend time in.
So I mean, could the entire island of Manhattan be a sensitive place?
I wouldn't say. I would say in specific places. Like I think the petitioners stated that subway was not a sensitive space, which I don't agree with. I think a subway is a sensitive space because that is a place that people are people are spending time in, and same with malls and schools.
But sidewalks, I mean, if you go to any sidewalk in Manhattan, it's pretty crowded. Lots of people bustling. I mean, would every sidewalk in Manhattan be a sensitive place?
I would say yes.
So then what's not? I mean, the entirety of Manhattan Island would be crowded. I mean, there's not many empty places there.
I do see that, but I think that any place where people are residing in is a sensitive space.
Thank you, Council. You have about 40 seconds left. You can wrap up.
Okay.
The Second Amendment. Oh,
No, you go.
I mean, okay. The Second Amendment and its limits are clear. These limits apply to the person's well-being and mental state, as well as sensitive spaces, and are rightfully enacted to ensure public safety. It can be implied, according to the facts of the case of Heller, that concealed carrying is included in this. The petitioner's argument is not supported by the Constitution, as in this case, public safety is being threatened.
Okay, thank you so much. Now we have 5 minutes back for petitioners. Whenever you're ready.
Thank you, Your Honor. I think it'd be vital to bring up a point that respondents had discussed, which was the application of strict scrutiny, where they had said that it was the least restrictive means in terms of the New York legislation. And if you were to look at page 17 of our brief, we go into how this is just not the case for New York's law, and how it has, if anything, further withdrawn more of our rights, as it would be much less restrictive to have a shall issue regime, as the majority of most of the states in the U.S. already do. And I think that's important to bring up as well in terms of like the danger of firearms. Like the state of Minnesota, which is a shall issue regime, has one of the lowest firearm mortality rates in the U.S. according to the CDC. And even though they have this shall issue policy for licensing, so I think it's important to consider the fact that.
Would you, Council, if I can interrupt, would you require all 50 states to adopt the same rules in Texas, the shall issue regime?
I think my point in bringing this up, and I don't think that we should apply the same rules everywhere. Maybe Texas is a little too lenient in terms of the shall issue, but if some states
but then if you don't want shall issue, what regime do you want?
I'm saying I don't want Texas's shall issue, Your Honor.
So
because
which shall issue do you want? I mean, isn't shall issue mean you get a permit without, as long as you pass a background check?
Well, I believe that there are, yes, the background checks, the criminal record looks, that is all, a fine requirement. And I think that some states maybe have more leniency than others in terms of who they let acquire license through the shall issue. And so like I brought up the state of Minnesota, who has a shall issue regime and still has that low firearm mortality rate. So I believe that if they're doing something better than, say, Texas, then why not apply some of their.
Let me just ask this for Mrs. Downey. What happens if, let's say, in 5 years, New York comes back and says, we now have shall issue, and the homicide rate has quintupled? All these people just shooting down the street. People have never shown any violence before. So, oh man, I have a gun, boom, 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 right? And there's a dead body piled high. What do we do with that? What do we do in that case?
Well, Your Honor, in the case that we would see violence rising, exponentially, I look to the process and the way that laws were applied and compare and contrast to states where it seems to be effective, where it seems to be.
New York didn't have it before, but now we rule for you, and now have all these dead bodies. What do we do with that?
Well, Your Honor, I think it's not necessarily guaranteed to be because of the change.
It's hypothetical. I mean, just assume that happens. Should that change the way we approach cases? Should we revisit our case in a couple of years if it turns out that we were wrong?
Yes, Your Honor. I think if it was proven that we were incorrect, then some reevaluation would be.
So then why do we have to make the mistake? Why do we have to tolerate dead bodies? Why don't we just rule against you now and just avoid the carnage?
Well,
because
Your Honor, it's because I think when we look at New York's right now, the spike of gun violence is through the roof, and a majority of this is not from people such as the clients of the petitioners.
It can get worse.
Who are seeking to legal. Sorry,
but it can get worse. How does the court survive the stench of all those dead bodies?
Your Honor, I think it's a tough status quo to tackle. And I think that in this case, the court makes mistakes, right? And people make mistakes. We're human, but at the same time,
Yeah, that's my daughter would say.
if we like to, if we would like to consider it from that point of view, then we would like to consider what is the best possibility for New York states to reduce that rate, because we don't want more people dying.
Okay. All right, Counsel, you can wrap up with 40 seconds left.
Thank you, Your Honor. And to conclude with our argument overall, we believe as side petitioner that our argument is the only argument that is not only historically supported by things like historical precedent in our own country, as well as English common law, and as well as the general sentiments of the time of the founding, that not only is the argument of the petitioners the only argument in which is constitutional and is aligned with the principles in which this country was founded, but also given the application to the modern day, besides the constitutionality aspect, petitioners are also the only case in which it's defending the liberties and the freedoms in which Americans are entitled to. Thank you.
Right on time. Thank you so much. All right. Thank you both. If the petitioners response, please come back on camera. Let's see. You're good. Okay. That was really good. I gotta tell you, that was a tough round because we were really hard on you. We were pushing both teams, I think, beyond where you were comfortable. And I think you all held composure. You didn't panic. And you didn't crumble. And a couple of things you did that I liked. So one thing you did was when a few points, I think you realized that maybe you said the wrong thing. You said, well, Your Honor, maybe I misspoke. That's okay. That's not only okay, that's actually good. We're not perfect. That's my daughter would say, accidents happen, right? Whether in the potty or the courtroom, accidents happen. We make mistakes. And the best thing you can do for your credibility is to confess and say, fess up, Your Honor. I think I may have misunderstood your question. I think I didn't give you quite the right answer. I think maybe I said the wrong thing. You're allowed to say that. And of course, okay, that's a credible advocate. That's a credible argument of why maybe you didn't get the right answer before. So I encourage you to always do that. A couple of times, I think you maybe said the wrong thing, like, uh-oh, and then roll with it. So Heller did not say intermediate scrutiny. It said heightened scrutiny. And I think you recognize that and you rolled with it as well. So in our brief, we said, I think Ashley asked this question, in our brief, we said intermediate or strict, roll with it, right? If you find that you've made a mistake, there's nothing wrong with that, right? Roll with it and sort of, the judge is not going to try and just kill you on this one, might, but the judge more likely try and get you back on track, which is what I think we were trying to sort of guide you back to the path. Right. There's always gonna be technical issues with Zoom. If you couldn't hear the question, that's not your fault. But you said, Your Honor, can you please repeat the question? Fair point. You're allowed to do that. When you get a question, pause just for even a second before you start answering, because that gives you a second to sort of plan an answer. I think you'll find it. A lot of the questions I asked you are really tough line drawing questions, like how many dead bodies do you want and how much evidence do you need, right? My goodness, I feel awful asking it, right? But it's designed to get you out of your comfort zone and designed to push you in a place you don't want to go. Because once you say the entire island of Manhattan sensitive or the subway is sensitive, where do you draw that line? And there's not always a good answer. If you actually watch the Supreme Court arguments on that exact question about, the subways and stuff, they were not good answers. They were, I think, lousy answers. So I think you really reflected, you were understanding that I was trying to lay a trap for you and you didn't want to step in that trap. And they kept shoving you into the trap and you kept dancing around it and trying not to put your foot in the trap. And eventually you get your foot in the trap, right? Eventually you're going to get stuck in it. But then you pivot from a weakness to a strength. And you say, well, Your Honor, that may be true, but, or Your Honor, there may be a lot of dead bodies, however, right? And you can sort of escape from it. But really, you're arguing far beyond the years of a high school student, right? This is not normal high school knowledge that you have. You have much deeper knowledge that you would have in law school. So I'm very proud of you. And I expect great things of each and every one of you. I mean that sincerely. Hope to see you in law school in a couple of years, winning moot court championships. Ashley and Reed, who are in law school now, maybe have some more relevant advice. But I'm sincerely grateful for all of your attention.
I know, I thought y'all did really good. I mean, they were hard questions. There was a couple things I liked y'all did. So y'all were really composed when you talked. You talked slowly and didn't rush your argument, which I think really gets your point across more. Both sides actually brought up the other side's point when they were talking without being prompted by us. And that doesn't happen often. And I think that was really great that y'all did. And then I think, Peter, you referred to a page in your brief when you were arguing. And I thought that was really great because it shows that you're prepared and you know where things are at. The only negative things I would just want to emphasize is that maybe when judges are talking, just remember, like when you hear them talking or when you see the little yellow box around, just be quiet and listen to their question, just so you can be able to get exactly what they're saying. And the only thing other is watch the likes and ums. And I struggle with this all the time. And Professor Blackman gave some advice earlier, is maybe just record like what you're saying and rewatch it, and you'll notice how many times it's said. And I struggle with it all the time. But otherwise, y'all did really good.
Yeah, the ums and buts are, we're all guilty of those. And really the only way to break it is to record yourself and listen back. And it's so hard to listen to yourself, right? You ever try it? Because like,
Brutal.
oh my God, it's so uncomfortable. But I've been teaching for a decade. I still listen to my lectures. I replay them back. I play them back. They're on YouTube. I listen to my lectures to see what I did right and what I did wrong. You can never do that enough. And when you listen to yourself, you start saying, oh, wow, I'm going fast. Oh, wow, I interrupted that judge. That was not a nice thing to do, right? You'll be your biggest critic, but you'll grow, you'll strengthen from that criticism of yourself, right? Your criticism of yourself is more important than whatever I can say, whatever Ashley can say, whatever we can say. It comes from you, so you know it's legit. And look, listen to let your parents listen to it, let your teacher listen to it, right? You know, let your brother or sister listen to it, and they'll give you advice, and you'll become such a stronger advocate. Reed, what are your thoughts?
Yeah, I think everyone did a really good job of not getting flustered. I did not let up on anyone. I
Nope.
asked you law school level questions that I hear myself in moot court, that practicing attorneys and judges would give a law student or a lawyer. So y'all are competing at a very high level, and y'all are well on your way to being lawyers if you want to be lawyers. I will give some criticisms. Just a few. I'm really big on, and I think my co-justices, if I've noticed this, if you give a case or a statute, I need to know where it comes from. So if you give me just a case and it's a case name, and maybe that's on me for not remembering on page 30 of your brief when you said it, but when you give a case name, you could just say in X versus Y, this court held. Okay, perfect. That lets the court know that we're talking about a Supreme Court case. And that's important because I'm sure you guys have learned what stare decisis is, right? And precedent matters, especially when it's coming from the Supreme Court, and it would bind the court usually in lower case and in subsequent cases. So, and if it's from a lower court, from the Second Circuit or something like that, tell us. Oftentimes that matters as well. Sometimes judges have high opinions of lower court judges. And then further, just another thing, watch the deference of the court, not only being quiet when a judge is speaking, but also calling them your honor. I know I can think of a specific example, at least for a district court judge, whenever they were called ma'am, and that's a big no. And then same thing for sir. It's always your honor, so your honor, or the Supreme Court justice so and so. So watch the sirs and ma'ams. That's a no-go in this
Oh
context.
boy, don't no sir, no ma'am, no sir, no Bruno, right? No. Sorry.
Yeah, and other than that, good job, guys.
Right. I always like to pause and give you a chance to ask us some questions about a competition, about law school, whatever you want to ask. Free, ask me anything, as they say.
So I have I have a pretty big interest in pursuing law school when I'm older, and I've gotten advice from some previous law school students who said they recommended taking like a year or two in between undergraduate and law school to get experience. So like actually, become like a paralegal or something, and then go to law school instead of having that like the 7 years of schooling back to back. So I just wanted to maybe get some opinions.
That's excellent advice. Routinely, I talk to undergraduates who want to go to law school, and I say take a year off and become a paralegal, because you might decide you hate it. You might decide you absolutely hate it because you'll be surrounded by lawyers. But you don't even need to wait for a gap year. You're all in high school. If you know a lawyer, to have lawyers in your family, ask to volunteer at their office for a couple of weeks over the summer. Right? There's nothing wrong with that. Right? Ask to volunteer. Ask to, even just making copies or sitting in court hearings. Do that. When you're in college, whatever town you're in, ask a local law firm, do you need an intern? Unpaid, you're not getting paid, my friends. But work for a few hours at a law firm a week. When I was in college, I did some research for an attorney in town on credit scores, which wasn't particularly compelling, but I really liked it. It was my first legal research and I enjoyed it. And then when you actually get to your junior year or so, you can think thinking about the LSAT, the LSAT. You're doing your SAT now. Yeah, there's another one called the LSAT in a couple of years. Well, actually, no, the GRE, the school's taking GRE as well now, so either one. And you think if that's worthwhile. Law is not for everyone, but I think all of you at least have the aptitude for, whether that's your passion, I couldn't tell you, but you all have the skill set. You're all well on your way. Other
Yeah, I
questions?
agree.
Yeah.
I took a semester off. I graduated a semester early. I took summer classes and went and worked at a law firm before starting law school. And I think it was a big deal because I think law school is a commitment. So you have to know that's what you want to do.
Thank you very much.
What other questions you guys have?
This summer I'm doing the National Youth Leadership Forum for Law and CSI. Do you think that's a good practice for like actual, like a simulation of court?
I am not familiar with that competition. I'm sorry. Reed or Ashley, do you know about it? I'm so sorry.
I'm not familiar. I'm sorry.
What is it? Tell us. I've never heard of it.
So I think my teacher recommended me for it. And I think it's like it's in DC and it's just a week of like preparing. I think you get a case and then you get assigned a part in court, and then you just, I guess you just like do a simulation. I think you also work with, I think you get to choose between law and CSI law and CSI program, and then you team up with them, and I think they work with like a simulation of like dead bodies and things, and then
cool.
you kind of like
Dead bodies. We're talking about piles of dead bodies, right?
yeah. I'm really excited for it, but I just didn't know if it was something that was like.
It sounds awesome. I would want to do that when I was in high school.
Apparently a George Mason. It seems like a good thing. I mean,
George Mason. That's where I went to law school.
yeah. So I just Googled it. But I mean, what year are you in high school?
I'm in 10th grade.
Sophomores, my goodness.
Sophomores. I mean, look, you're building your resume, and that's just the stuff that it'll add to you and your experiences as you're applying to college. Nothing like that is gonna be a bad idea.
And this too, you're all semifinalists in this competition. Put that in your resume. It's a line in your resume. Tell us when you go for a law school interview, like, oh, I was a semifinalist in the high school moot court competition.
Yeah, not many people did a moot court competition before they were in law school, let alone did a moot court in law school.
In sophomore year in high school.
Yeah.
All right, what else do you guys? Any questions? Things in your minds?
So I'm a freshman, and
Look at this.
before this competition, I had absolutely no interest in law, but I think that having this experience definitely sparked something maybe. But are there any things that any programs or sources or just anything that you would recommend to kind of go further into that before college or even during college, other than obviously interning? But any just like explore more of that?
Well, I think short of interning, asking lawyers just to shadow them for a day. It's a very useful thing. If you have a lawyer in your family, your friends, during the summer break, say, can I just follow you around for a day? Let them go to court, let them see them go in their office, and then they're gonna show you, they're gonna be so proud to sort of show off what they're doing. Find your local district attorney office if you can just intern there for a couple of weeks, right? I can give you books and things to read, but really what will sort of spark your fire is seeing people do it in real life. Or go to court. I mean, courts are open to the public. I don't know if COVID, wherever you guys are living, I'm not sure what the rules are, but at least in the past, every court you walk in, you sit. You go to a website, you look at your local court, you look at the calendar, what's in the docket for today. Might be a criminal case, might be a family case, a custody dispute. Courts now are on Zoom, so you don't even have to leave your couch, right? You can just watch a court proceeding on Zoom. Listen to a Supreme Court oral argument. In this case, right, if you haven't listened to the New York State rifle and pistol argument, go to the Supreme Court's website. All the argument audio is posted and listen to it. It'll take you about an hour and a half and just hear what the arguments are. And you'll see the arguments at sensitive places were not so good at the Supreme Court. They were kind of a little iffy, but I think that's a good place to start. But I'm, freshman week, 13, 14 years old, you guys are well on your way.
Also, look and see if your city has a teen court program, because I did that in high school, and it's like through the JP court, and you can represent like other students that are doing like speeding tickets and stuff. And it's like the whole process. You have to do like opening statements, questioning, closing. So that was something big that I did.
And we hope you can play again next year. We'll have another competition for the same tournament next year. All right, anything else, you guys?
I just have one last quick question.
Oh, Emma, did you have a question?
Oh, sorry.
I did. Peter, you can go.
No, I already went to one, so you tell you.
Thank you. I was just curious, since you guys already, you guys have some experience with law and law school. Was there anything in particular that you guys did that you felt was helpful or better preparation? Because I know that not a lot of schools offer specific like pre-law undergraduate degrees. So I was wondering like what hands-on experience, again, like besides like interning and stuff, that like you felt was helpful or unhelpful, or like put you at advantage or disadvantage of things like that.
Sure, and this is a common question we field. There's no one right major. I didn't major in law. I majored in computer science. I think Ashley was in business and Reed has political science. But the only advice I'll give you for college is to learn how to write. It sounds silly, but it's true. Write as much as you can. I didn't write much in college. Like Ashley, I took all my AP classes in high school. I basically had zero writing in all of college. I placed out of everything, which seemed like a great idea at the time. So I got to law school, like, oh my God, I can't write. And that's sort of struggle. But whatever major you have, whatever you decide to pick, take classes where you have to write a paper, right? Or you have to write a seminar paper, or you have to write a research paper, a term paper, or a thesis for your major, right? Those skills will be very useful. Whatever you decide to do, it will be lovely. You don't need to have a political science background. It might help you in a few classes like constitutional law, but really not much, right? But learn how to write, learn how to speak, do debate, do forensics, right? Do moot court, learn how to speak and write. But writing is actually more important than speaking. It's true.
Just to add to that, keep reading. Just don't ever stop reading. It's tempting to watch Netflix in your off time. It's tempting to watch YouTube videos or whatever instead of getting your news from less digestible sources, I guess. But if you read good writing, it'll make you, if you read good writing, it'll make you a better writer. So they kind of go hand in hand.
All right, what else?
I just had a quick question more about like the technicality. So during like, I know my speech, when you brought up the dead bodies, what is your best?
That was an awful question, but I had to.
No, I mean, it's all fair game. What would be your best strategies for combating like a highly unlikely but still circumstantial?
Right. So what one of your colleagues in one of the other rounds did, which that was good, was Heller said we don't engage in interest balancing, right? We don't balance the pros and cons of constitutional rights, right? That balancing was done in the Second Amendment, was ratified 200 years ago. So I would say, Your Honor, Heller already said we do not engage in sort of interest balancing of social costs. That's simply not relevant to our decision. And one of your colleagues made that argument earlier today from one of the other schools, and that was a good answer. So, but the bigger answer is pivot to a strength. Don't start saying, well, this number of dead bodies is okay, but this, you're done, you're toast, right? Pivot to a strength.
Thank you.
What else? All right, Reed or Ashley, anything you want to add for them?
I think so.
All right, well, that was lovely, guys. I'm very proud of all. You should be very proud of your accomplishments. We'll be posting the scores tomorrow, and we'll be posting the videos on YouTube later tonight, and you can go back and watch it and critique yourself, but just be proud of what you did.
Thank you very much.
Okay.
Thank you.
All right, if the students can leave, we'll confer with the judges, and we'll be in touch. Thank you so much.
Great
Thank
job,
you.
guys.
Okay. All right, that was okay. Not the best round, but it was okay. Yeah, the dead bodies one. I don't know if you got the reference, but with the stench, but during the arguments in abortion, Justice Sotomayor said, "How will the court survive the stench if we overrule Roe v. Wade?" So it was. They'll be fine. All right. All right, you guys. We'll come back at 2:00. But let me put my scores in, and then we will have a few more, and then we'll be done. But so far, I'm thinking I'm seeing where who's going to advance, but we'll see what happens in the afternoon.
All right. See you too.
Yeah, see you later, guys. I'm going to stop this recording.